Good evening. Good evening. I'm Seth Lon, and as faculty director of the Moot Court program, it's my pleasure to welcome you to the final rounds of the 51st annual Sherman Minton Moot Court competition. Ordinarily, the pleasure of greeting you would fall to our Dean, Austin Parrish, but tonight Dean Parrish is Justice Parrish, as he's very kindly agreed to take the bench along with our other judges, 3 federal district judges, to whom we're also very grateful for taking the time to come down and join us tonight. And we're also grateful to Professor Inga van de Kruze, who helped arrange for their attendance here today. And also Professor Ryan Scott will be joining the other justices on the bench. Our competition is named for Sherman Minton, Indiana's only native-born U.S. Supreme Court justice, a 1915 graduate of our law school, a Seventh Circuit judge before taking the bench, and perhaps fittingly for this November 11th, a veteran of the First World War, the cessation of which, as many of you know, I think Veterans Day, originally called Armistice Day, originally commemorated. Justice Minton is gazing down on us all from his portrait at the back of this room, and I'd like to think that he would be proud and pleased of the kind of civil and rational debate that you're going to hear tonight. I think that debate is a welcome reminder, maybe particularly in this year and this season, that we can resolve major issues in our society through that kind of rational and informed discourse, and that's an important part of the rule of law. I'm now going to turn this over to Andrea Douglas, who's the Chief Judge of the Sherman Minton Advocacy Board. Before I do that, I just wanted to give a couple other thank yous. First of all, to all of the competitors who are here tonight. In addition to the 4 finalists that you were going to hear, there were 114 other competitors who began this competition. They worked with these finalists, sometimes in teamwork with these finalists. Their efforts inspired the efforts of the finalists and the other competitors, some of whom you'll be introduced to shortly. We couldn't do this competition without them, as well as without the contributions of the Moot Court board members, many faculty and staff of the Baier School of Law who donated their time, and also those of you who are simply friends and family and supporters of the students who went through this process. You made an important contribution too by your support of them. So without further ado, I'm going to turn it over to Andrea Douglas, the Chief Judge of the Sherman Minton Advocacy Board.
Good evening, everyone. Again, we really appreciate you coming, and we are very pleased to host you this evening to listen to phenomenal students give phenomenal oral arguments regarding the fictitious case that the board produced. So I first want to just start off by introducing you to the board. Some of them are still working in their capacities outside of this room, but I will still call their name and acknowledge them. These are full-time 3L students, and they take the time out of their day, nights, weekends, every day since May to make sure that this program goes as smoothly as possible. And so I am beyond proud of the work product that we have produced, and I do think that most of the credit goes to these individuals. And so I will call their names as well as their positions, and they will stand, and I just ask that you hold your applause until after all of the board has been announced. So as far as the executive board is concerned, we have executive judge coordinators who are outside of the room, Ms. Toni Dorson and Mr. Eric Least. We have executive competition coordinators. Out of the room is Ms. Nicole Berwick. In the room, we have Ms. Elena Harris. Our executive problem coordinators is Mr. Jimmy Moffitt and Mrs. Helen Wang. Our executive research and advocacy coordinator is Mr. Evan Starr. And serving under a dual capacity is our executive research as well as competition coordinator, Ms. Kayla Fry. And this is your executive board. I will now move on to our competition board. These individuals, again, are part of the backbone of this program. These individuals helped assist with your briefs. They helped calculate different things. They, I'm sure, were confidants as well. They made sure that everything in the rooms where arguments were being held were structured and that everything went accordingly. And these competition board members, if you are here, we ask that you stand. And again, I just ask that you hold your applause until the final board is announced. We have Ms. Jace Bourne, Mr. Emmanuel Choco, Paige Coomer, Ms. Angel Davis, Mr. Brandon Dawson, Mr. Elliot Edwards, Catherine Fishman, Michelle Fox, Marie Forney, Allie Gardner, Mary Mancuso, Brian Meachik, Audrey Sales, Rachel Phillips, Malin Snicker, and Houston Vasile. This is your board. So now that we've announced the board, it's time to announce who really matters in the competition, which are your participants. As Professor Lon stated, the structure of the program, we started with 118 participants out of the 2L class. As 2Ls, those are the only individuals who are allowed to participate. And from that 118, that was actually whittled down to 64 with a combination of their brief scores as well as their oral argument scores. After those 64 were determined, it was then brought down to 32, which only their brief scores counted in the rounds of 16 in the rounds of 8. And then finally, the people here tonight have, again, made it to the finals. And so I will start off by naming those individuals who made it to our octafinalist round, which is our top 32. Or excuse me, I'll start with our semifinalists, which is our top 8 competitors. Again, I will only be announcing 4 as the other 4 will be competing this evening. First, disclaimer. I sincerely apologize if I mispronounce your name. I will do my absolute best, but please do not charge it to my heart. So Gina Batag, Brooke Harwood, Priya Prowit, Caitlin Sheets. These are your semifinalists. And I'm sorry, before you take your seats, can you just please turn around because the camera would need to see you. Thank you so much. And so going forward with our quarterfinalists, again, if you would just turn around so that you're not just staring at me and the board, that would be great. So our quarterfinalists are Kate Davenport, Tristan Fretwell, Hannah Kim, Justin Przejewski, Connor Richards, Patrick Robichaud, Robert Roulette, and Jeff Solar. These are your quarterfinalists. And now for your octafinalists, Mr. Jules Cantor, Ryan Daly, Morgan Darcy, Adam Farr, Jonathan Huff, Matthew Humble, Stephen Kibbe, Lisa Lafonarli, sorry, Lisa. Melissa Latini, Matt Pease, Tyler Selway, Brittany Skabowski, Anna Struggs, Alex Thibodeau, Erica Trabuzzi, and Megan Van Pelt. So in closing, and before I turn it over to the other part of the program that everyone has been waiting for, which will consist of us basically explaining the facts of the case, as well as the 2 issues that are at hand, I wanted to actually take the time to make a special announcement. During the moot court process, again, there's a brief writing component and there's an oral advocacy component. And as you know, in your program, there are several individuals who received brief writing honors as well as oral advocacy honors. And so one thing that is special to the board is the notion that we do have journals here at Mauer, and we have 3 journals here. And those individuals who run those journals, they take their time and they nurture and they guide students in their writing abilities. And all of our writing honors are not on journals, so doesn't mean that, to be on a journal you have to get honors. But I just did want to note that journals play a heavy part here at Mauer, and they are one of our flagship programs along with Moot Court. And so I did want to say that we believe that in 2016 that we have our first slate of journal and Moot Court leadership comprised entirely of persons of color. And we want to recognize this moment for the Mauer community. Each of these leaders was selected based on what they accomplished for Mauer, and each shows all students that they are welcome, that they belong, and that they can do great things. And in no way is this a reflection on Mauer faculty or Mauer staff, as we all know that Moot Court, as well as journal representatives, are student elected. So I wanted to take the time to recognize Ms. Melissa Logan, Mr. Brandon Dawson, and Ms. Annie Shea. And again, we are what we believe the first individuals of color to run the 4 flagship programs of Mauer. So I appreciate your time and attention, and now to the fun part.
All right, I don't know I'm supposed to follow that. Don't worry, I will not be rapping. All right, so what are we arguing about today? All right, now today's case is about a 17-year-old high school student athlete from Madeline Albright High School. His name is Augustine Covington, but we like to call him Augie. He was banned from a state high school championship game by his coach, Antonio Talampis. This state championship game was of particular importance to Augie because the last time that the school had won this championship was in 1980, in which his late father had captained the team. After the state championship loss, Augie's emotion turned to rage and anger, and he posted from the social media app QuickPics, which is basically Snapchat, a arguably threatening rap. This rap, the next day, man, who wrote these facts? The next day, he kept his regularly scheduled meeting with his therapist. During this meeting, he once again said arguably threatening language. When he got back to school, news of the rap had reached the principal's office. Also, his therapist had called the principal to warn the principal of these arguably threatening statements. Augie was later suspended, and he has now raised a claim of violation of his First Amendment.
So, this isn't on, is it? There it goes. So as Jimmy said, Augie made a possibly threatening statement to his psychotherapist. And during the litigation, the school district attempted to bring in evidence of that statement through the psychotherapist's testimony. Now, Augie blocked it using psychotherapist-patient privilege. Now, it's important at this point to distinguish between the ideas of confidentiality and privilege. Confidentiality between a patient and a psychotherapist refers to a psychotherapist's promise not to disclose the contents of what a patient said during a therapy session to third parties. Now, there is one very commonly, almost universally accepted exception to this, which is generally called the Tarasoff standard or the duty to protect. You will likely hear arguments about this today. The duty to protect says that a psychotherapist can disclose statements to third parties when there is an actual threat on someone's life or person. Now, privilege is a little bit different. Privilege refers specifically to the ability to block or prevent testimony in court. Now, psychotherapist-patient privilege was acknowledged by the Supreme Court in a case called Jaffe v. Redmond, which I'm sure you will also hear quite a bit about today. But the outstanding question in this case is whether there is a Tarasoff-like exception to that privilege. That is, Can a psychotherapist testify in court about his or her patient's statements if the patient made a threat on someone's life or person?
Now, the next issue will be a First Amendment issue, and that is whether schools can punish or limit online off-campus speech is an issue that has never been addressed by the Supreme Court. The essential question in today's case will be whether high schools can limit online off-campus speech, and whether Augie's speech in today's case qualifies as speech that can be limited by the high school. We will now turn to a news broadcast of this issue. Possibly.
Hi, I'm Jet Michaels, and this is the news.
Hi everyone, I'm Allison Apricot.
Let's jump right into our lead story. 17-year-old public high school student is garnering national attention as his fight for freedom has reached the Supreme Court of the United States.
Augie Covington of Madeline Albright High School was suspended after his therapist released information about an alleged threat on one of the school employees. During the same time, he released an ambiguously threatening rap and also threatened to expose athletic directors and boosters regarding suspicious violations.
As many of you know, Madeline Albright High School has been in the news many times for its outstanding athletic and academic achievements. It was once noted by President Obama as being a beacon of academic and athletic success in the United States. We have previously unreleased footage of Augie Covington from that very rap, and we will turn to that right now.
Hey man, get some quick picks.
Got it.
I can only keep this brief. Please do not mistake this beef for Drake and Meek. It is not fame or fans that seek when this jam leak. Forget Robert Williams and Narva Graham. I'm coming to hit 'em up like a real man. Mine made up, my plan's flawless. Only way we end in this, let's St. Crooks and Chris Wallace.
Wow, truly gripping stuff.
Sure is.
What happened to MySpace? Now, Augie is also claiming that his rap is protected by the First Amendment. This controversy has gripped the nation that has led many politicians, rappers, and community members to take a stance on this issue. I went down to Madeline Albright High School to ask the students how they feel about this controversy. Hi, I'm here with Remy Martini, the star captain of the 4x4 on the track team at Madeline Albright. Do you know who Augie Covington is?
Yeah, he's kind of a nuisance for the athletes right now.
Why'd you say a nuisance?
Well, he made a lot of allegations, and I know I'm being recruited right now by a lot of D1 schools, and so to potentially have allegations that I'm on roids or cheating in school, it's kind of affecting my eligibility.
Did you feel that any of his threats were to your physical nature, or were they just to the academics?
I would say both, because he did kind of make both types of threats, but also I guess the concerns with academics. I just took the SAT a couple of weeks ago, and so I know I'm kind of concerned about the validity of my scores now, but yeah.
Thank you for that. I'm here with Preet Milstein, a freshman at Madeline Albright High School. Do you know Augie Covington?
I do.
And what do you think about this recent controversy?
Well, it's ridiculous, man. I mean, he needs to come back.
And why do you think it's ridiculous?
They're just out to get us. The administration, are keeping us down.
And why do you think they're keeping you down?
They're like teenagers. It's really hard, man. Nobody listens. Just want to listen to our music, sing.
What did you feel about the rap?
I liked it. I thought it was funny.
Thank you.
Truly interesting stuff. Well, according to the newspapers, the Supreme Court is set to hear this case via oral argument on Friday, November 11th at 5 o'clock p.m.
Kids these days. And with that, we will have a word from our sponsors, and when we get back from the break, we will hear a word from our field reporter, Derek Most, that will gear you up for the winter. How to turn that suntan lotion into a healthy salad dressing.
I've been trying to do that.
Me too.
Before we go any further, I'd just like to say a quick thank you to two people. Jimmy and I were two of the main problem writers on this, but we had one more person to help us, Helen Wang. And we solicited ideas from the competition board to come up with these issues, and one of our issues, our First Amendment issue, was come up with by Catherine Fishman.
Okay, now going forward, cell phones off. It's all cool. All right. We are gathered here today to hear the oral arguments of Midlands School District versus Covington. Court is now in session.
The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
All right, you may be seated. Good evening, everyone. All right, we're on the record in the case of Midlands Consolidated School versus Covington. We'll be hearing from Mr. Shoptaw first, I believe. So, sir.
Mr. Chief Justice, and may it please the Court, my name is Benjamin Shoptaw, and I'm the attorney for the petitioner, Midlands Consolidated School District. The rise of social media has had numerous benefits in today's society, but it's also caused some major problems. Specifically, cyberbullying is continually on the rise, and it's more prevalent today than ever. And schools are the most common place where the effects of cyberbullying seem to be felt. And this is why schools need to have some sort of authority to help regulate off-campus speech to help protect all of its students. This court in Tinker established that schools may regulate speech in class or out of if school officials reasonably believe the speech will result in substantial disruption or material interference with school activities. Many lower courts have...
The disruption you're concerned about in this case?
What is the disruption?
What was the disruption that the school was concerned about?
The disruption was we had a coach that was concerned for his safety. He was concerned for his job. We had a student who skipped class.
Wasn't the disruption that the student was highly critical of the circumstances by which the boosters were funding the program? And isn't that kind of disruption showing some sort of favoritism and perhaps maybe even illegal activity by the school? Isn't that the type of disruption that isn't cognizant in this type of claim?
This disruption, we would say, is anything that would affect the school's environment of learning. And in the rap video, there were a lot of statements or suggestions made to what the school might be doing, what the athletics program might be doing. But he also made some threats against a coach in particular. We have a student who skipped class who got 300 to 400.
But skipping class isn't the kind of disruption that we would condone a speech consequence.
I believe that skipping class is, when we look at whether it was a substantial disruption, we should look at the entirety of all that happened. And I believe that the student skipping class was one specific fact that goes towards whether there was a substantial disruption to the school in its entirety. We have
if a student published an article in the local paper that said there was massive fraud ongoing in a public high school, and it caused massive disruption because of the turmoil of revealing that there was fraud and these illegal activities going on, could they censor that speech?
Not in that case, Your Honor. I believe that the test needs to be a school may regulate threatening online and off-campus speech. If it was reasonably foreseeable by the speaker that it would reach the school, and if it was reasonably foreseeable by the school that it may cause a substantial disruption. Why
doesn't the true threat doctrine suffice for that purpose?
I believe that the true threat doctrine doesn't suffice. This was not I believe we've conceded this was not a true threat. And I believe in the case of a true threat, then people like the authorities might get involved. They could go to them, the school could go to them, and obviously in that situation, the school would still have authority to possibly suspend or expel that student. Here, Augie made some threatening suggestions in his rap video, and they were enough to cause Bart Talampis to say he was alarmed and offended when he saw them. When he then shared them with his father, who also was very concerned with what was said, it was then shared with the school. And the school acted completely reasonably in then suspending Augie, as there were actual disruptions that happened. And so it was obvious that the school could reasonably foresee even more disruptions, that these disruptions could become a major problem in the school's learning environment.
Enough? Go ahead.
Please.
No, I was just going to ask, how far is Tinker equipped to deal with the modern realities that we're talking about in this case? Or are you offering a different paradigm?
I'm offering a different paradigm, one that's a little bit more restrictive than Tinker. Tinker is just that they have to reasonably foresee a substantial disruption. In ours, the first element is that it was reasonably foreseeable by the speaker that it would reach the school. Here we have him posting on Quick Picks. It lasted for 24 hours. He's friends with close to 150 students that go to the school, one of whom is Bart Talampis. And in the rap video, he is making threats to Bart's father. It seems very reasonable that he would know that this would get to the school. I believe Augie also testified when on page 40 of the Run the Record, when he asked, did you want to scare the school? He said, yeah, sure. I wanted to shake them up a bit. I was trying to show that I wasn't kidding around. He wanted this to reach the school, and that's the first aspect. The speaker had to reasonably foresee that it would reach the school. So it's a little more restrictive than Tinker in that effect. And we believe this test balances the protections given by the First Amendment and the extremely important and vital job of a school. A school's job is to educate, it's to help shape young minds, but it's also to help teach students how to be productive, how to be responsible, and in a sense almost how to be lawful.
What if instead of having his own rap, he was using, let's take a rap star, this isn't my long suit, but let's say, Eminem. Who has a lot of violent imagery, violent language in much of his music. And let's say he was on spring break in Germany. And he filmed him doing a rap of Eminem at a performance, but he substituted the name of the coach for some of the violent sort of imagery. Does the result change?
I believe in that scenario, the result might not change. It would depend on whether or not he did mean for that to reach the school. Here he clearly did. In that scenario, if the only difference is that instead of it's his own rap, it's a rap that he's kind of used from someone else, but he purposefully changes certain wording to threaten school officials, then I believe in that case it was certainly reasonable, if all of the other facts are the same, that would reach the school. And so then it would be certainly reasonably foreseeable by the school that a substantial disruption might occur from that. Although schools not...
I'd like to know what counts as a disruption, just to put a fine point on it. Is it enough that the faculty member subjectively feels afraid, feels threatened? Or do we need to parse the language and decide for ourselves whether we think that was really a threat or whether it was a mixture and ambiguous?
Well, I believe that there's never going to be a test where we get every single disruption and we really make it a specific thing. But I believe a disruption could be anything. In your example, the coach is feeling scared, his feeling like someone has called him out.
So change Tinker around. So one faculty member at the school says the black armbands protesting the Vietnam War make me feel scared. I don't know what those protesters are going to do next. And somebody decides to skip class as a result. Then the outcome in Tinker comes out differently?
I don't believe so, Your Honor. In Tinker, it said it has to be a substantial disruption. And I believe that those are two small disruptions, but they might not equal the level of what becomes substantial to the schools.
Wouldn't the plaintiffs, the students in Tinker have said we were trying to shake up the school? We were trying to send a message about how much we didn't like the Vietnam War.
And I believe that's true. In Tinker, I believe that it was political speech, and the school...
But isn't that the point? Aren't you going to have a whole...
Oh, no, you go right ahead.
Aren't you going to have a whole range of speech that's purely political speech, clearly protected, which would disrupt the school, that doesn't involve violence and threats?
Your Honor,
under your test, that would cover that, right? They could penalize.
In our test, a school may regulate threatening online. So if it's purely political, or if all Augie would have done was purely say that these are issues with what's happening in the boosters and the athletic program, then no, the school wouldn't have been able to, even if there might have caused a disruption. But in this case,
that's where I'm confused why the true threat doesn't protect you sufficiently. If you have a threat of violence that reaches the level of a true threat, you can suspend, punish, you can call the police. So why should you get an additional layer of protection and when it doesn't rise to a true threat, and in this case is making a political commentary as well about what the school's doing?
Well, in the true threat doctrine, that's a very serious threat with real intent to harm. Augie wanted to shake the school up, and part of, I think, what he wanted to do was kind of make Coach Talampis feel a little scared. And so I don't believe that Coach Talampis truly believed that Augie was going to come and maybe hurt him, in his sleep and really chalk his body out. But at the same time, his threats were made specifically to scare Coach Talampis, specifically to scare the school in part. And in the case where you make these ambiguously threatening remarks, it could cause many students to feel scared. Maybe they don't realize that they weren't true threats. Maybe they took them seriously. In this case, we have students who were trying to get him expelled, and we have students in an art class making shirts that say "Free Augie." That's a pretty substantial disruption to the school day, especially when we consider there are 700 athletes at the school, and we have 300 to 400 signatures from students, from athletes to from everybody, as Preet Milstein put it. That wanted to expel Augie for what he said. There was concern that Augie would hurt somebody.
Those facts are also the same sort of facts you would see if you had pure political speech, right? So under your theory, that would seem to be the same whether it's political speech or not, right?
Correct, Your Honor. But I believe that there does need to be a line drawn. The school obviously should not be able to regulate everything and anything they want. And if it's purely political speech, then no, a school shouldn't be able to regulate, and it might still have a substantial disruption, but that does fall under a student's First Amendment right, and they should be protected. But when a student is...
So can I just ask then, so on your test, just so I understand what you're proposing, how do I capture what you've just said, that it doesn't apply to political speech, but it does apply where there's a substantial disruption? What's the test that you're applying? You gave me 3 tests, but that doesn't seem to capture what you just talked about.
Our test is a school may regulate threatening online and off campus, and it is only if it is threatening. If it's political and threatening, then they may regulate, but if it is strictly political and that is it, then the school does not have the authority to regulate. It has to be in some form threatening in nature where a threat is made, and then from that, if it was reasonably foreseeable by the speaker that it would reach the school, as well as if it was reasonably foreseeable by the school that the speech may cause a disruption. Here, it was certainly reasonably foreseeable that Augie's speech would get to the school. Again, he posted it for 150 classmates to see. It was on the weekend where kids aren't even in school, so they have much more time to be on social media. And it was posted where the main target, or one of the main targets of the rap, was Coach Talampis. His son saw the video, and Augie knew his son was a follower.
Why is that test relevant? It seems to me that's only relevant if you're treating it like activity that's occurring on campus. Presumably anybody who's trying to make a statement and wants it to reach the school and wants it to reach the community, if we adopt that test, it seems like any statement is going to fit under that test.
Well, Your Honor, we could certainly think of scenarios if you have a private social media account, maybe you don't have many friends from the school, and so it's not reasonably foreseeable that it would reach the school. But here, Augie's specifically calling out the school. You could make political speech that has nothing to do with the school. You could say a lot of things on social media that have nothing to do with the school, but when you are specifically calling out the school, it definitely seems to go towards the reasonably foreseeableness. Thank you.
Okay. Yeah. All right. Thank you, Mr. Shoptaw. All right. So, Mr. Spindler.
Thank you, Mr. Chief Justice, and may it please the Court. My name is Alex Spindler, and I represent the respondent, Augustine Covington. My opponent is correct. Public schools do have a special place in our society. They function as inculcators of values and academic excellence for our sons and daughters. However, such power should not be wielded without unauthorized or unchecked authority to the point where it could curtail the rights of expression and speech that all children, including Mr. Covington, possess.
Listen, what's a school supposed to do? You've got a student who is making almost sort of overt threats to a teacher. What are they supposed to do with that?
In this scenario, Your Honor, and as a strategy or even a standard for future courts, we believe that the First Amendment does not permit a public school to regulate purely online speech so long as the contents of the speech are not acted within the physical bounds or the program bounds. So in this scenario, the language and the key word is that does not necessarily arise to a true threat. That falls more under the level of artistic expression. In the lower courts...
So wait, are you advocating for a standard by which any online speech that occurs off campus is beyond the bounds of discipline by school authorities?
No, Your Honor. There are certain exceptions, obviously, for true threat doctrine or other kinds of speech that that automatically do not receive First Amendment protection. So if it were to amount to a true threat, or say if it were any other number of fighting words, obscenity, or anything like that, in which case multiple cases of the Supreme Court have already decided that that automatically is precluded from receiving First Amendment protection. Now, the main distinction and why this standard works best is we want to prevent the school not only from chilling the effect of potential artistic expression, but also we do not want public schools to rise to the level of mind control. We are not saying that there are not scenarios in which case the school might be a little bit weary, but the problem with using a tinker doctrine in this case...
If a student posts something online saying, I think one day I'm going to kill the professor, and it doesn't amount to the level of a true threat because it's not specific enough, and the school says we're going to suspend you for a day until calmer minds control and we can actually figure out what you actually meant by that. You're saying that's a violation of First Amendment, right?
Yes, Your Honor.
But isn't that silly?
Isn't that what we need right now? We've seen a rash of school shootings and movie theater shootings, and we're all trying to figure out how to prevent the next one. Don't we need a rule that would permit us to take immediate action without legal consequences and paying the costs of lawyers and all of the rest?
Yes, Your Honor. I understand that there might be a need for a rule. However, given First Amendment doctrine, specifically Tinker as a template within the public school arena, it is not permissible for the public school to go forward and to punish. And in fact, going back to your point, Justice Parrish, there are many cases, one of which including...
there are many cases that actually do allow that, right? There's a number of cases where they've suspended people for a short period of time when there's been activity that has not amounted to a true threat. And the school is concerned about the safety of its other students, right? And that's entirely in the past. Courts have found that to be permissible, right?
Yes, Your Honor. Some courts have found it, but there have been other courts, such as Berge ex rel Berge v. Colton School District, where there was a posting online that said, pardon my language, that the bitch should be shot. That was posted as a social media site online, and in that case, both the judge and no reasonable juror could find any indication of a true threat or a reason why the student should be suspended.
I don't understand why the location of the speech should matter. So in Morse v. Frederick, we held that the Bong Hits for Jesus sign was properly prescribed because it advocated for drug use on campus. What difference would it have made if the banner had been set up just across the street from the school instead of directly on campus? Why should that 2 inches make any difference to the constitutional power of the school to prevent damaging speech that advocates drug use?
One of the main differences, Your Honor, is that in the case of Morse v. Frederick, they decided that that was a school-sanctioned event. So in that case, the school still had proper authority to see and regulate what was happening.
But as I understand your proposition, Tinker totally evaporates. The Tinker power to regulate totally evaporates as soon as you're physically off of school grounds or outside of a school-sanctioned event. What sense does that make? Why should it matter if the students in Tinker have their black armbands across the street as opposed to on campus or the Bong Hits for Jesus sign?
A big difference, Your Honor, and this goes to a point and to questions that were posed to my opponent, is that Tinker, given its facts, its circumstances, and its difference in time period, does not catch up to what is happening in today's day and age with online speech that happens presumably in a cloud. And this speech specifically, and speech that no doubt is likely to occur in the future, happens on this ephemeral kind of cloud.
I take the point, but I don't see how it assists your argument. Doesn't the fact that there's so much more speech happening online make it even more important that we recognize how off-site speech might disrupt the classroom, the school grounds?
I understand your concern, Your Honor. The issue I take, and an issue that I think should be undertaken by the court, is where does it stop? If Tinker can be utilized in going forward and having schools to regulate online speech, whether that be on Twitter, Facebook, QuickPick, Snapchat, going forward, where does it stop? Does the school end up becoming mind police, where they go in and have to dissect every single post made, especially students at this young and impressionable age, 16, 17 years old? And as we know, more and more students are gaining access to social media and other communications. So they probably will be saying things that might be misinterpreted in a wrong way by the school, acting as the authority who wants to suspend or expel. But from the child's point of view, or even from the speaker's objective point of view, as my opponent would point out, that simply is not the case. And a lot of students don't actually mean the things that they put online.
What standard are you actually advocating for? And tell me the standard. If I'm a school administrator and I'm trying to navigate this, I'm not a lawyer, I'm just trying to deal with, what is the standard that's going to govern me?
The standard is that, though you are a school administrator and though you have a reasonable expectation of having deference since you are a public school and inculcator of value, that the First Amendment does not permit the public school or school authorities to enter into the realm of online speech when it occurs both outside the program bounds of the school and as well as the physical bounds of the school. It is that sharp...
So my initial question, the answer is yes. If they're off campus, case closed. Right. The administrators have no authority to do anything about it. Correct. That's what you're suggesting.
Correct, Your Honor.
Even if they're threatening or they're engaging in sexually explicit material or whatever it might be that might be viewed by an administrator to be sort of untoward behavior, you're out of luck.
But, Your Honor, that is one of the exceptions, is that if it does amount to a true threat, which both parties in this case have conceded to that it does not, if it is a true threat, if there's sexually explicit material, fighting words under a Chaplinsky doctrine, child pornography under a Ferber doctrine, that speech is automatically precluded from receiving First Amendment protection.
Yeah, but there are true threats, and
Yes.
then there are ones that are close to the line but not true threats. And as an administrator of a public school, don't you have some obligation to protect the student body and err on the side of safety?
Absolutely, Your Honor.
How do you do that?
There's no denying that a school is given deference to take into account the safety of the school and the student body. However, an automatic jump to suppressing the speech, enacting a suspension or an expulsion or another disciplinary matter.
Good question. If it wasn't based on speech, but instead somebody said this particular student has started acting really erratically, they bought a whole bunch of different guns, and the school says we're going to suspend them for a day until we get more information on that. For you, no problem there.
No, no problem at all.
Okay, so now if the person who has the guns and is erratic calls up and says, I'm going to come to the school and do something, right? Or posts online, I've lost my mind. Now we've got a First Amendment problem?
There would be an issue in the sense that, yes, the school will take the reasonable steps necessary. However, the issue I have with suppressing the speech is...
Well, we're not suppressing the speech, right? Or the school doesn't seem to be suppressing the speech. It seems to me strange that you can have a situation where the acts can lead to a valid suspension in order to protect the safety. And then when you have the speech that confirms that activity, making it even stronger that you've got a problem, that the school can't act, and also now inoculates or ends the school's authority from being able to protect its other citizens from harm. Isn't that an odd interpretation of the First Amendment?
It might be seen as an odd interpretation, Your Honor, and there's no doubt that schools are given the deference they need in order to take the steps they need. However, there are other alternatives instead of the school acting in its capacity under a Tinker doctrine, for instance, calling the local law enforcement, seeking other alternative routes as a means to protect the immediate threat at issue. And another main issue
What's law enforcement going to do about it? If it's not a true threat, they have no authority to do anything about it. So who fills the void?
Well, in that case, if law enforcement is not, if there's no way for the law enforcement to get involved, say there's no grounds for a warrant, there's no actual reasonable suspicion at hand, this is not to say that the school cannot do something. However, a rash jump to automatic suspension because of the presence of potentially almost threats, even though they're not true threats, the school can still investigate, potentially reach out to the parents of that student, ask to see if something is going wrong, potentially setting up a counseling session. The school can seek other healthier...
So let's assume the school does that, and it confirms that although it's not a true threat, that it's got a serious problem, and then it wants to engage in some sort of cushion period to see how the student's acting after they've made these sort of threats of violence. Any ability for the school to do anything there that's on the discipline side?
On a disciplinary note, I am not suggesting that a school is without any kind of power.
Well, why not? Because I thought your theory was that the First Amendment sort of meant that there couldn't be any action, that you couldn't suppress it. If you're just talking about degree, then isn't it just a fact-specific question as to whether the particular threat in the particular circumstance warranted the suspension in the individual case?
Well, to be fair, Your Honor, in the scenarios that you had presented, that is where it comes out of the realm of the online speech and it comes into speech that is directly advanced towards the contents of the school. So other steps have been taken that would lead to a different path, or at least a different circumstance in which the school does have some room to act. The standard that we have proposed...
Just that one of the things they could do is, well, maybe have a counseling session. Well, what if the kid says, go scratch? I'm not showing up. Then what?
In that scenario, Your Honor, I do believe that the school can take reasonable authority in doing alternatives like that. But I think the issue is that, regardless, if a school were to take disciplinary measures, suspend, expel, take any other kind of action, a suspension or expulsion on its face is not going to prevent that action from occurring. Yes, the student might be precluded or prohibited from attending the school, but if a student is determined to shoot up a school, he or she will shoot up the school. And so, until the point where if the school might perchance want to, if those alternatives such as starting a counseling session weren't available, they might call upon the local police officers if they do believe that such a threat were available. But an automatic threatening of suspension or expulsion is not the proper step that we want for the school to take. And additionally, with this case specifically, and the threat for future cases, is the idea of hampering artistic expression.
So why not just have a clear line that I think the other side was arguing, that in situations where the speech involves threats and violence, it gives the school broader range and broader leniency to act. In situations where it is not involving threats and violence, then you have your artistic expression, then you have your political speech, and then the First Amendment considerations trump. Why isn't that a good balance between the concerns of protecting other students and the individual's free speech rights?
Your Honor, because such a bright line rule as that continues to extend the power of the school beyond where current Supreme Court precedent as well as other cases have stated. Currently, the Supreme Court, under the Tinker Doctrine, as we have all been discussing, has certain regulations concerning substantial disruptions, reasonableness, and looking at whether or not affects the environment of the school. Specific language being the ability to leave the schools alone, the ability to let students be alone in a peaceful environment.
I would read this as a narrowing of the Tinker Doctrine, not an expanding of it, that the kind of substantial disruption that would need to exist on off-campus speech that's online that impacts the school would be ones where there's threats and violence to members of the faculty or other students. That seems a narrowing of the Tinker Doctrine, at least in this circumstance. And so doesn't that protect you more than what if you read the Tinker Doctrine as itself, it seems like any disruption is enough to get
Yes, Your Honor, except for the facts of the Tinker case and the fact that social media communications have expanded far beyond the reach of what schools deem as reasonable and what is within their powers. It creates more of a fuzzy scenario. So if a school reasonably interprets something to be somewhat threatening, then you get into the issue of, well, can a school go any forward and demarcate that this is threatening and this is threatening? It gives too much power to the school, and I hope that this court please adopt this standard and all other tests forward. Thank you.
All right, thank you, Mr. Spindler. You were out of time, but I'll give you a minute if you have anything to respond.
Mr. Chief Justice, and may it please the court, the respondent's test leads us down the dark and scary path. He says that the only time a school may regulate is if there is a true threat. But in that case, that's not the school's job to regulate. If there's a true threat, that is law enforcement that should get involved. So we're effectively saying that if there's any ambiguous threat online, if there's cyberbullying going on online where the school students are affected, the school can't do anything because it's not this true threat, right? And that's far too dangerous when cyberbullying is just so common and so prevalent. It affects so many students. And the school's job is to help protect those students, help educate those students.
But even under your theory, cyberbullying wouldn't be covered there because I thought you told me that there needed to be a clear threat or violence, even if it didn't amount to a true threat. So that wouldn't cover general cyber and emotional bullying, would it?
No, maybe not general cyber emotional bullying, Your Honor, but certainly there's cyberbullying that happens where threats are made or threats are suggested. And in that case, the school should definitely be able to regulate in those circumstances to help protect its students and help promote the educational environment.
Does proportionality go into any part of the analysis? It seemed like one of the concerns was the type of suspension. Am I right? This is a full semester suspension?
This was a full semester suspension, Your Honor, and I believe that.
How does that have any proportionality to the shouldn't that raise a flag here that they're actually not penalizing or they're not punishing for concerns over the school student safety, but rather they're doing it for some other reason, perhaps the political reason that they've been embarrassed?
Your Honor, I believe this court said in Wood v. Strickland that it's not the rule of federal courts to set aside decisions of school administrations, even though they might view them as lacking in judgment. And I believe that we need to defer to a school board and school administrators.
But we do that all the time when we think the judgment isn't protected, right? So I guess what I'm saying is if we think they're penalizing, I thought you said that if they're penalizing because of the political nature of the speech rather than for the protective purposes, then that's entirely appropriate for schools to regulate. And so don't the facts of this particular case really seem to suggest that they were regulating and punishing for other things, political speech, rather than the potential harm to students?
Your Honor, I believe that the Principal Hugh's testimony is that her first concern was for the safety of her students. And Coach Talampis was concerned for his own safety. We have testimony from one student where she said she was concerned.
Same analysis if they had suspended him for 2 years.
If they had suspended him for 2 years, then certainly that seems completely unreasonable.
Is there a reasonableness proportionality principle in Tinker?
I don't believe there's a reasonableness proportionality principle.
So you could have suspended him, you could have expelled him forever.
I don't believe so, Your Honor.
State school board could have said, the state's Department of Education could have forbidden him from receiving any education in the state of Calumet for all time.
Well, Your Honor, I believe that the suspension, if it seems entirely unreasonable, then the student might have a case to fight that. But here, a semester suspension when you're halfway through the semester, it seems to me, may I finish?
Yeah, you can finish.
It seems to me that this is entirely reasonable, especially when we consider the substantial disruptions that did happen and the speech that Augie actually said. Thank you.
All right, thank you, Mr. Shepner. Okay, moving to the second issue in the case, and I guess we have Ms. Goldkopf up first. So.
Mr. Chief Justice, and may it please the Court. My name is Stephanie Goldkopf, and I represent the petitioner, Midlands Consolidated School District. When this Court decided Jaffe and established psychotherapist patient privilege, it acknowledged that this privilege is not absolute, just like all other evidentiary privileges. First, it established in its holding that this privilege only applies to confidential communications between a therapist and the patient. Second, in footnote 19 of the opinion, the Court noted that there might be an exception in a dangerous patient situation. And the 10th Circuit in Glass, using the language directly from that footnote in the Supreme Court, established the dangerous patient exception test, which is a two-pronged test. First, if the threat is serious when it was uttered, and second, if there was no other means to avert the harm besides disclosure.
Why do you need the privilege here? Why wouldn't it be just sufficient to have somebody testify that somebody had called and said that a threat had been made? Why do you need the testimony of the therapist herself in order to substantiate the case?
Your Honor, so the testimony of the therapist herself makes clear allows the Court to understand what the school had at its disposal when it made the decision to suspend Augie. And so the information is important because the therapist is in the best position to know the mental state of the student. So in this particular case,
if we allow the exception in this case, it swallows the privilege. The facts, if you read the testimony of the therapist, it's basically Augie says, I'm so mad at these people, I could kill them. I'm kidding. Of course I would never do that. So that's the kind of back and forth that you want to encourage, I would think, between a patient and a psychotherapist. But so under your suggestion, he's out of luck. That doesn't make sense to me.
Your Honor, so that's why the test with the seriousness of the threat is important. So the therapist is in the best position to know whether the threat was serious or not. If it was, I believe the language that Augie used was much stronger than what you characterized.
But can I clarify? Are we debating whether she had the ability to disclose in the initial, or are we debating whether she had the ability to prevent her from testifying in the underlying civil trial? Because it seems to me it's pretty clear that she had the ability to break the privilege or the confidentiality to disclose the threat to the school officials. That seems to me very different than whether she's then later permitted to testify in a civil case in a way that's contrary to her patient.
Your Honor, based on the language in the opinion in Jaffe that the confidential communications is what is protected, I would argue that the duty to disclose, and once the testimony is, once the disclosure is made by the therapist, then the third parties are under no obligation to keep that information private and could, in fact, disseminate that information to anyone. There is no confidentiality.
But why make it worse? It seems to me that the other doctrine is entirely focused on safety issues. And so you want dangerous people to go see patients or to see therapists so that they don't harm people. And you want to encourage that. And that's why you have confidentiality. And then if it does create a level of threatening conduct, you allow that to be broken. And allowing testimony in a civil case by the therapist has nothing to do with the safety. You're no longer, you've broken the chain. You're no longer protecting anybody from the dangerous conduct. It's solely to prevent liability in a civil action. Isn't that right?
No, Your Honor. Particularly in this case, that's not the case. So the plaintiff was contesting the suspension, which was brought against Augie as a way to prevent the harm to the school and to Coach Talampis. So in this case, the plaintiff is using the privilege as a sword against the school and not allowing the school to defend itself properly. It was one of the things that the school considered. Her disclosure was one of the things considered to make the decision to suspend Augie. And for that reason, that information is needed by this court. And in a civil case, particularly because it's just liability, unlike in a criminal case where maybe the therapist would be testifying against the defendant, would sufficiently damage the relationship between the therapist and patient or deter future patients or this patient from seeking medical care. In this case, that policy reason for establishing this privilege does not exist. Dr. Bruno.
But it seems stronger, right? So what happens if you can do it in civil cases, right? It would seem to me that you take a small exception, right, when there's a direct immediate harm that you can tell somebody in order to protect harm, and now you say it opens up everything. So once you have like you're saying, once you have a little area of light, you can drive a Mack truck through that exception, right? And you're allowed to testify in any situation about the confidential communications. If I was somebody who was worried about seeing a therapist, that'd be very concerning for me, right?
Your Honor, in this case, the therapist is only testifying to the threatening language that Augie made and some of the history, but none of the confidential communications that weren't related to the threat itself. So it's
That's exactly what we want to encourage patients to share with their therapist. So that's the core of the confidentiality and the privilege, is when you go to that person, you know that you can share your innermost fears and anxieties, and these are the things I'm afraid I'm going to do. So that's exactly why we want the privilege, isn't it?
Your Honor, yes. So protecting the relationship between the patient and therapist is very important, and it's very important that is why the privilege was established. But once that disclosure is made to a third party, and if it's the type of language...
disclosure to the third party, when she calls the school principal, waits a whole overnight, an afternoon, an overnight, and until things open in the morning, and then she calls in the morning, at that point, she's shared it only with one person. It isn't out in the community. It's not on the public record. It's not anywhere. It's at least limited at that point. But by the time it's in a civil case, we're in a court of public record. We have the gallery here. It's everywhere.
Your Honor, so once it was disclosed to a third party, and in this case it was disclosed both to Coach Talampis and Principal Hua, it was discussed with the school officials when they made the decision to suspend Augie. And it's quite possible that this note might have been made in his school record. So, and Coach Talampis and the school officials were under no duty to protect the privacy of Augie. And so that information could very well get out to the public. And in this case, with a civil case particularly, the patient can't, it won't damage the relationship between the patient and the therapist anymore. The patient is angry with these people who now know about his threat.
Do you think he's going to go to any other therapists after this? Like, it seems to me it's very different to have somebody, the coach, testify what they had heard, and have somebody other than the therapist testify. But to have the therapist testify, I can't imagine him going back to this therapist again if his therapist is testifying against him in the trial. Right?
Your Honor.
Therapist. I mean, again, it just strikes me, who in their right mind, knowing this, is going to seek help from a therapist if they know that the therapist might well feel compelled to go to the authorities. So patient goes in, talks to somebody and says, you know, doctor, I had a dream last night. I was choking my brother. I love my brother. Why am I having these dreams? I need help. So you're going to sort of quash somebody who wants to engage in that kind of dialogue, aren't you?
No, Your Honor, and I think that the second prong, the no other means to avert the harm part of the test, sufficiently protects speech like that. So when the patient is asking for specific help with this issue, or the therapist, who's in the best position to analyze the mental state of the patient, makes the determination that there's no other way to prevent any harm from happening, there's no way for the therapist to continue to treat this patient, and the only means of helping is disclosure, then it's not breaking the therapist-patient, it's not destroying that relationship between those parties, because with this particular patient...
Yeah, but again, that's describing the Tarasoff exception, right? And so where I'm struggling with is not the argument that Tarasoff exception could apply, although that may be a question, but rather the second jump that says that once the Tarasoff exception applies, all bets are off. And there I don't understand the policy. Can you address that? Because I understand the policy behind the Tarasoff, and that makes a lot of sense, and I understand why that's incredibly narrow. But you want to go much broader than that to say once that exception has occurred, everything else is permissible, and this patient or this therapist can testify in any case, even in civil cases. What's the policy behind that?
Your Honor, it's to protect, it's so that patients can't disguise their threats, put them to their therapist, and then know that they won't be liable for anything that they say to a therapist, and then potentially act on their, even though after the duty to disclose, even though the third party is put on notice, that doesn't mean that that third party is sufficiently protected. And in this case, the school needed to suspend Augie in order to protect its student body. Now that suspension is under attack by the plaintiff, but the plaintiff doesn't want to allow. If
we disagree on the First Amendment argument, and we find that it was not permitted under the First Amendment to censor that speech and suspend, then does that mean you also lose on this argument because it no longer becomes necessary to have the therapist testify?
No, Your Honor. And the reason for this, too, is that when the disclosure is made, the therapist has, I'm sorry, Your Honor, to address your question, sorry, could you repeat your question?
Yeah, I haven't got a clue what I asked either. So why don't you?
If you lose on the First Amendment argument, and all you have to rely on is what he told the therapist, what effect does that have on the policy that you're suggesting?
So losing on the First Amendment claim, well, then the testimony, though, is moot, right?
All you have is the testimony of the therapist at that point, right?
Right. But would that be to defend against the First Amendment claim? So the testimony is being used to defend the First Amendment claim against the First Amendment claim by the plaintiff.
Can I quickly ask, the source of this privilege is Rule 501,
yes.
And we're based on our reason and experience, we're supposed to come up with privilege. And when we decided Jaffe, a primary basis for the decision was the fact that all 50 states recognize a psychotherapist privilege, and we relied on that as a basis. What do the 50 states say about an emergency exception? Do all 50 states recognize an exception for emergencies of this sort as a matter of state court evidentiary privilege law?
So are you asking about the duty to disclose or state privilege?
State privilege.
Oh, Your Honor. Yes, Your Honor. I do not believe, and I'm not 100% certain of this, but I do not believe that all states have a uniform approach to this privilege law. And I know I'm out of time, but may I finish?
You may finish your
answer. I would
answer.
also like to point out that with the duty to disclose, not all states have the same level of duty to disclose. So thank you, Your Honors.
All right. Thank you. Okay, Mr. Andreas.
Mr. Chief Justice, and may it please the Court, my name is Austin Andreas, and I represent the respondent in this case, Augie Covington. This case represents an attempt to transmogrify the psychotherapist into a prosecutorial asset by the state, despite the negative consequences that transformation would have on the psychotherapist-patient relationship.
But you chose to bring this case. If your client didn't want the therapist to testify, he didn't need to bring the case.
Your Honor, it is irrelevant whether or not the privilege is used as a sword or a shield, because in the Jaffe v. Redmond case, this court overcame a presumption against privileges where it needed to balance the effective mental health treatment across the nation versus the need for probative evidence. That balancing prioritizes effective mental health treatment, whether or not over probative evidence, whether or not the privilege is used as a sword or a shield. And therefore, the fact that Augie used the privilege as a shield does not mean that the therapist's, any information from the therapist would trump the effective mental health treatment of individuals in this country.
Well, didn't your client, wasn't he warned specifically by the therapist that, listen, this is what my obligations are. If you utter certain things, I have obligations too. So where's the unfairness in that?
Your Honor, the Ninth Circuit in a case titled United States v. Chase elucidated that there is a distinction between confidentiality and privilege. Confidentiality includes the broad blanket of protection state laws afford to protect the psychotherapist and patient relationship. Privilege is the patient's specific right to prevent the therapist from testifying at trial. Therefore, the warning that was given was a warning that the therapist may have to break confidentiality. The warning was not that the therapist would have to break privilege. The court...
That's just wordplay. What's the difference?
Your Honor,
between the two things?
This court should adopt a bright-line standard to remove this blurring between confidentiality and privilege. This court should recognize that the only way a patient may waive privilege is if the therapist gives warning that they will have to testify at court against them, because that is the specific right at issue.
Isn't that wrong, though? Isn't the right at issue, at least from Tarasoff, is the concern about harm? And isn't that what we're worried about, is destroying the sanctity of the patient-therapist privilege, the therapist-patient relationship, not the privilege, right? The harm is revealing what was told to the therapist, right? It's not the harm that their therapist is the one that's saying it, is it?
Your Honor, there is a distinct difference in the effect of a duty to protect disclosure to break confidentiality and a waiver of privilege. The waiver of privilege has a much more deterring effect on the psychotherapist-patient relationship because the patient has to watch as the therapist goes to the witness stand and discloses statements made in therapy to a prosecutor or a plaintiff and a judge. And that has a much more deleterious and chilling...
Well, then don't bring the lawsuit. That's your choice.
You are correct, Your Honor, but the patient still retains the specific right of privilege to prevent the therapist from testifying, whether or not the privilege is used as a sword or as a shield. It is the patient's specific right to prevent that statement.
Why doesn't truth-seeking trump that policy argument when the person who's bringing the civil suit is engaged in some falsehood? In this case, maybe it's not clear, but suggesting that, no, I didn't make the threat. And then the therapist, something that was already revealed to other people, confirms that, in fact, the falsehood was made. Doesn't the interest in the court in truth-seeking there trump, particularly in situations when the confidentiality has already been breached?
Your Honor, the Jaffe court already overcame this presumption against testimonial privileges by balancing the effective mental health care treatment of patients in this country. It is such an important public policy in this country that alone, the privilege must be preserved.
Let me ask the same question of you that I asked of Ms. Goldkopf. What do the states in their evidentiary rules say about this exception to the psychotherapist privilege? That was central to our reasoning in Jaffe.
Your Honor, I am not sure of what exactly these states have, but this court has given evidence that they do not intend to include the dangerous patient exception in their doctrine. In 1974, Chief Justice Rehnquist submitted a proposal to Congress advocating for the psychotherapist patient privilege before this court established such a privilege in the Jaffe decision. In that proposal, the Chief Justice advocated for 3 exceptions to the psychotherapist patient privilege. And according to the court in United States v. Chase, quote, conspicuously absent from that list was the dangerous patient exception.
Well, that's the federal proposal. I'm wondering what the states are doing, and I don't see how we can decide this issue without knowing the answer to that question. Part of our point in Jaffe was we need to have a privilege that is coextensive with the dominant approach of state privilege law. Otherwise, we're going to either insufficiently protect. So if we grant a privilege, if we fail to grant a privilege that the states have granted, then we're undermining state privileges. Conversely, if we fail to recognize an exception, then we're needlessly blinding ourselves to information that's already going to be admissible in state court. So I guess this means I have to send my clerk to go do some research for me, but what are the states doing?
Your Honor, paired with the information that this court had previously denied to include a dangerous patient exception and the fact that the Jaffe court took consideration into the policies of these state courts, of these state policies, I could only infer from that there is no dangerous patient exception among the 50 states. Otherwise, the Jaffe court would have included an explicit dangerous patient.
I'm sorry. Let me just. Does it all change? Let's say at this preliminary injunction hearing, Augie got on the witness stand, and Augie said, "Yeah, I made this rap video. I was goofing around. I like rap music. Of course, I had no intention, but I have never, ever threatened that coach ever before." Let's say he testified to that.
Your Honor,
so what would happen in that situation? Are we going to allow him to essentially lie about and get away with that? Or in rebuttal, would they be allowed to call the therapist to say, actually, no, he did make this threat to me?
Your Honor, the imperative of mental health care in this country, prioritized by the Jaffe court over any probative evidence. Any probative evidence.
But your answer is yes. He could get on the stand and lie about it.
Your Honor, he could, but it's up to the opposing side to disprove it without the therapist's testimony.
What if we didn't have the rap in this case? All we had was the statements to therapist Bruno, who then called the people she did. That's all we have. Suspension takes place. We're now at the civil trial.
Now, Mr. Andreas, aren't you asking the school to choose between the safety of the kids and civil exposure? In other words, if they can't defend themselves based on reasons such as this privilege, aren't they going to side on risking the safety of the kids and of the coach?
Your Honor, the need for preserving the aura of confidence and trust between the psychotherapist and patient is so important that this court must require.
It's already been broken. She already called the coach and the school.
Your Honor, confidentiality was broken. There is a distinction between confidentiality and privilege, and the impact of a break in confidentiality is much less than a break in privilege, because the patient does not have to watch as the therapist gets up to the witness stand and testifies against him.
But the school has to watch itself get sued and can't defend itself, can't use it as a shield in this situation as opposed to a sword.
Your Honor, the school must present their case without breaking privilege, because this court prioritized mental health care at such a high priority that it trumps any probative evidence that a therapist could provide.
For damages, right? So instead of having the argument about the suspension, you're now suing for damages, claiming there was a violation under 1983, which presumably you could. That means you're saying that the suspension is actually less important. The action of the confidentiality is less important. What's really important is for you to be able to have a way to lie on the stand so you can get money. Is that what you're like? That seems to be where we're getting at, right? That in any civil case you can prevent them testifying so that you can win a judgment damage, even though the court and everybody else knows that the testimony is untrue.
Your Honor, the distinction between civil and criminal cases in this situation is irrelevant, because no matter what, the therapist will still have to, if the privilege is waived by the dangerous patient exception, will still have to go to the witness stand, and Augie will have to watch as his therapist discloses statements made in therapy, and it would be...
So you're saying that there could be no exception to the privilege?
That's not what we are advocating, Your Honor. The standard we are proposing is that the exception must comport to the underlying policy which was formulated in Jaffe. There are exceptions which to the psychotherapist.
Example.
Involuntary commitment hearings, Your Honor. That is a valid exception, and one of the exceptions that Chief Justice Rehnquist submitted to in his proposal to Congress. That exception advances the underlying policy inherent within this court's decision in Jaffe, because it...
Are there any others besides that?
Yes, Your Honor. Chief Justice Rehnquist listed two others. First was if the testimony was necessary as an element in affirmative defense, and the third was if a mental examination was required by the judge.
Isn't this in the nature of evidence that's necessary to prove an affirmative defense?
Your Honor, it doesn't qualify under that, because the dangerous patient exception, it does not prove a defense. It would be used in opposition of Augie in this case. It would not be an affirmative defense for him.
I don't see why those three situations are any different from the objection that you have to this exception. Wouldn't the person be forced to watch the therapist give the testimony in public in all of those three situations as well? How is this any different than
Your
the
Honor,
context here?
The dangerous patient exception is different from those three exceptions because it completely eviscerates the relationship between a therapist and a patient, because it would be used against them to punish them, either in a criminal case.
But that's not true, right? So I understand it in a criminal case where it's being used to prevent the punishment. But in this case, you've put the testimony at issue at a civil case where you're seeking recovery. It seems to me that your argument that there shouldn't be a difference between a sword and shield is actually wrong, that there should be a significant difference as to whether this is being used against them for criminal purposes or whether they're using it themselves as a way to inoculate themselves or to be able to succeed in a civil case. Why isn't that a meaningful distinction for us?
Your Honor, the distinction is that the therapist would be used against the patient. And the three exceptions I advocate for...
That's not true in the involuntary commitment context?
Your Honor...
It's being used against the patient to put them in the hospital, potentially for the rest of their life. Why wouldn't that chill the relationship?
That is correct, but the understanding of the court in United States v. Hayes in the Sixth Circuit is that still offers a benefit for the patient because despite their own will, they need to be committed to preserve others and themselves. In contrast, the dangerous patient exception is used exclusively in opposition to the patient. Therefore, there's a distinction between the three exceptions that the Chief Justice Rehnquist proposed and the dangerous patient exception, which completely eviscerates the relationship between a psychotherapist and a patient. However, this isn't the only issue that this court has to address. This court should also reject the Oster waiver framework. And that's because the Oster waiver proposed by the Fifth Circuit incorrectly.
Couldn't you have solved this yourself by just conceding that the confidentiality was broken and that and conceding the fact that the school was notified that you had made a threat to students and teachers at the school? If your client had conceded that, then the school wouldn't have needed to prove the facts that they had a basis for making the suspension, right?
Your Honor, the duty to protect covers the field. The law as it stands protects third parties sufficiently. The duty to protect allows the therapist to break confidentiality to protect third parties.
I'm saying that if you're saying that there's a distinction between the privilege and the confidentiality, and the concern is having the therapist testify on the stand, couldn't you have avoided all that by just conceding the factual predicates that in fact that you had made a threat in the therapist's office, so you had conceded the breach of the confidentiality? That would have limited it no more to the Tarasoft exception. It means that you couldn't wax differently on the facts than what's true, and you would have prevented the harm to your client by having the therapist testify on the stand, right?
Your Honor, the fact remains that the opposing side could still call the therapist, and the patient must retain the right to prevent that. Your Honor, I see I'm out of time. May I finish?
You can finish your thought.
The patient must retain that right to prevent the therapist from testifying, to insulate the atmosphere of confidence and trust between the psychotherapist and patient. And for those reasons, I must urge this court to affirm the lower court's decision. Thank you.
Thank you, counsel. Counsel, I think you were out of time, but I'll give you a minute or so to wrap up or rebut anything that counsel argued.
All evidentiary privileges require confidentiality, and all evidentiary privileges have exceptions. Particularly when the policy behind establishing the privilege is frustrated, an exception is needed. I'll give you an example in another context. In spousal privilege, husband and wife, if the two parties are opposed, so it's a husband suing a wife, there is no spousal privilege because the policy behind spousal privilege is to protect the sanctity of the marriage and the harmony of the marriage.
Do you agree here there's a difference between the confidentiality breach and the privilege? Respondents made this distinction between disclosure of the confidence versus the privilege itself.
Your Honor, we would argue that once confidentiality is broken, privilege is waived as well. However, because there is a compelling interest to protect the patient-therapist relationship, there's also the component of the dangerous patient exception. So in the dangerous patient context, when you're dealing with a patient that is making serious threats, there's no other way to avert the harm, and that information is disclosed, and thus confidentiality is broken. That narrow situation, in that context, the privilege should be waived. So once the policy behind the privilege, again, here it's to protect the relationship between the therapist and the patient, and once that's frustrated, his enemy...
Does that also apply in criminal cases? And so if there was a later case brought by the client where the government was attempting to use the testimony of the patient for criminal sanction against the defendant, does that also apply in the same circumstance? Is that the same result?
Your Honor, here today before this bar, you do not need to decide whether there is an exception in the criminal context. It does seem that in the criminal context, there might be more of a compelling interest in protecting the relationship between the therapist and the patient, because if it's been used as a shield for the defendant so that they not lose their freedom, that seems like that would the policy justification that there's severe damage to patient-therapist relations, not just in that context, but in the larger context, that case might be different. But here today is in the civil context, and there that same interest where it's usually going to be used as a sword against discovering the truth. The truth-seeking value of the information is more valuable in the civil context, and no one's freedom is at risk.
Do we have any other situation or other cases where we have trumped, if we're no longer focused on the protective aspect of the exception to the doctrine of the Tarasov, do we have ones where truth-seeking trumps those that narrow exception? My understanding is all the other cases we've sort of limited to situations when there's imminent harm, and therefore we're focused only on safety to the public. Do you have any other situations where truth-seeking has allowed us to expand that exception beyond the protection aspect of it?
Your Honor, I see I have enough time to answer the question. Your Honor, I'm not aware of a case where that's the case, because most of the cases that deal with this dangerous patient exception are in the criminal context. So we're dealing with a situation where it's being used as a shield to protect the defendant and not as much in the civil context. Thank you, Your Honors.
Thank you, counsel. Okay, we'll deliberate and give you our decision as soon as we arrive at it. So we'll be in recess. All right, you can be seated. So formal.
Thank you all again for coming tonight. My name is Eric Least. I'm one of the executive judge coordinators here with the Sherman Minton Moot Court Board. And I'm just going to give a brief biography for each one of our accomplished judges tonight. So our Chief Justice for the evening is Honorable Philip Simon. He is the Chief Judge for the U.S. District Court of the Northern District of Indiana. He is an alumnus of this law school. Judge Simon. Judge Simon graduated from the University of Iowa in 1984 with his undergraduate degree, and prior to his appointment to the bench by George W. Bush, was the chief of the criminal division for the U.S. Attorney for the Northern District of Indiana. Proceeding down the line, Professor Ryan Scott is a professor of law here at Maurer, as many of you know. He received his BA from Macalester College in St. Paul and his JD from the University of Minnesota. Professor Scott teaches criminal law and federal jurisdiction here, and before coming to Maurer, worked as an associate in the Supreme Court and Appellate Litigation Group at O'Melveny & Myers, LLP in Washington, D.C. Judge Jorge Luis Alonso is a judge in the U.S. District Court for the Northern District of Illinois. He was born in Sagua La Grande, Cuba, before coming to the United States. Judge Alonso received his BA from the University of Miami and his JD from George Washington University. He spent 11 years as a judge in Cook County, Illinois, prior to his appointment to the bench by President Barack Obama. Judge Judith Levy is a Bloomington, Indiana native, so she's a Hoosier. She received both her BS and her JD from the University of Michigan, and then worked as an assistant U.S. attorney and adjunct professor at the University of Michigan Law School until her appointment to the bench by President Barack Obama. Our final justice for this evening is Dean Austin Parrish, who has been the dean here since 2014. He received his BA from the University of Washington and his JD from Columbia University. Before coming to Maurer, Dean Parrish was a member of the faculty at Southwestern Law School in Los Angeles, California, and was the interim dean and CEO upon coming to Maurer. Thank you all. Mr. Chief Justice.
Okay, thank you. But before we reveal the decision of the court, I guess we've been asked to give some feedback. And Dean Parrish, if you'd like to begin, if anything you want to say, or
I thought you
go
guys
right down the road.
I thought you all did a wonderful job. It's always impressive, and you guys did an exceptional job. My only one comment was I thought all of you forensically were great. We pressured you, and you responded well. Sometimes I think you want to think a little about where you might be able to concede, because I thought there was places where you probably could concede, and it wasn't going to hurt you. But overall, it was a privilege to be able to judge you guys. I thought you all did wonderful, and very proud you represented the school so well.
I think you all did a phenomenal job. I think you had hard positions to take. It's difficult to figure out where to draw the line. You picked a place to draw the line, and you found the reasons and drew upon the cases and seemed to know them well, and you had an ability to go back to your argument when you got thrown off. So I thought it was phenomenal. I'm really happy that I got to be here.
Yeah, it's such an honor and a real privilege, to be here. And it's just terrific to see the level of competence from you folks. Because, listen, I'm in court every day. and it's a daily disappointment. Okay? Seriously.
Yeah.
And so, 5 years from now, or a year from now, you're going to be out, you're going to be representing someone. And it's going to matter. So, care about what you do and do like you've done today, and your clients are going to come back to you, and then they're going to pay your bill. and that's what's going to matter. I mean, I have nothing else I can say. It's just a terrific job. Honest to God, super impressed. And thanks for having me. So.
Yeah, I want to echo that. It's an honor. You guys were wonderful. All four of you were wonderful. The only criticism is that you made our job hard. Our job would have been easier if you guys weren't so great. So congratulations to all four of you. And I also echo our chief's impressions of being on the bench and watching what actually happens there. I had to, in the last two trials, I had to say to my clerk, not only has this guy never done a trial before, I don't think he's ever seen a movie about a trial. It can get pretty bad out there, so it is actually wonderful to hear you guys and the pride that you take. Keep it up. Great job, and it makes me feel better about the future. Wonderful job.
I will echo all of that. Just fantastic work. This competition makes me so proud to be a member of the faculty here year after year. And as long as we're doling out compliments, the board did once again a fantastic job. What an interesting problem. It's such a great competition year after year. Keep up the good work. Some of you had tough positions, either because the problem gives you a difficult one to decide, or you made a strategic decision to go big, rather to advance the most aggressive form of your argument. And I will say, all of you had a great sense of the policy arguments that you were going to rely on in the end to win, because there was a million ways of asking tricky doctrinal questions, and we love to indulge them. We're lawyers. But you all had a really good sense of where you were, what the appeal you were going to have to make in the end to win your case. And that's a great intuition to have as attorneys. So really well done.
So 30 years ago, I participated in this competition, and I got bounced in the semifinals. And so you all, I expect to be on the Court of Appeals someday. So I'll announce the winners. And before I do, I will say that truly, and I'm not just saying this, everybody received a vote. That's how close it was. And so, with that being said, the two winners are Mr. Shoptaw and Mr. Spindler. So. it could not have been any closer. So I've been told that there are complimentary kind of beverages and those sorts out here. So I hope to be able to meet with many of you out there. So congratulations.
Congratulations.
Yeah.